Commission is being used as a highly politicised inquiry. What we've seen today is a very serious situation where documents which are supposed to be provided to legal representatives of parties and only to those legal representatives have been widely leaked to the media. The union solicitors, Slater and Gordon, today have written to the Trade Union Royal Commission calling for an investigation by the Federal Police as to the circumstances of the leak. But what we can see here for sure and for certain is that this Royal Commission, which has already been criticised for an apprehension of bias, is now involved in the leaking of confidential material. This is not done in the pursuit of justice. This is not done in order to get to the bottom of a case or find facts. It is done to demean people and their union and to smear them, and we urge a thorough independent investigation of this leak today.
What's your reaction to the recommending of criminal charges against Queensland Union officials Dave Hanna and Michael Radbar by the Royal Commission?
Well, first of all, to put it into some context, what you've seen here today is counsel assisting's submission to the Commission. So this is not a finding by the Royal Commission. This is merely counsel assisting, if you like, the prosecutor saying this is what we believe the Commission should do. So in relation to that, it's very important that it not be characterised as a finding. Secondly, in relation to Mr Radbar, the union stands by Michael Radbar. We are very confident that it's impossible to make a valid finding based on what counsel assisting have put, and even if a finding were made, it would have no legal consequence, and in fact we believe the chances of a successful prosecution based on what we've seen are remote, so remote as to be ridiculous. In relation to Mr Hanna, Mr Hanna's membership of the union was terminated. We would simply say this: Mr Hanna will have to deal with the consequences of his actions in a criminal court, and he can take whatever steps he needs to defend himself in relation to that matter, and like anyone else, he's entitled to the presumption of innocence.
Will the union pay for legal representation?
Well, the union will pay for legal representation for its members. We won't be paying for legal representation for Mr Hanna, as he's no longer a member of the union.
So was Mr Hanna lying when he said that Mr Radbar had instructed him to cover up security cameras?
Well, I'm not going to go through a blow-by-blow commentary about all of the evidence, but Michael Radbar has a reputation for being a person of integrity. Those who saw Mr Hanna's evidence can make their own judgments about his truth and veracity as a witness.
Was there something rotten in the Cfmeu offices at the time?
I'll tell you what's rotten. What's rotten is a circumstance where you have a politically motivated Royal Commission dedicated not to getting to the bottom of the facts, not to finding out what is going on in an industry like the building and construction industry. Rather, it's dedicated to pursuing a political agenda on behalf of the federal government. And that's what the Trade Union Royal Commission's about. That's why you're seeing documents which ought to be restricted to the parties that have not been published, have not been authorised to be distributed to the public, distributed to the press. This is a Liberal Party kangaroo court.
What evidence do you have that it was the Commission itself that leaked the documents?
Well, absolutely none. Absolutely none. It might have been the Liberal Party, it might have been the man on the moon, but somebody leaked the documents, and it sure wasn't the Cfmeu.
What makes you describe this distribution of documents as a leak? Where does it contradict the proper legal process?
The Royal Commission, under the Royal Commissions Act, has prescribed a practice direction, and the practice direction is that these submissions are published on the Commission's court book. Whilst they are published on the Commission's court book, they are restricted to the legal representatives of parties, and this is very strictly enforced. In fact, the union solicitors would not even be able to provide a document on the court book to me as their client. They sign documents when they are given access to the court book. Very limited numbers of people are given access to the court book, and they agree to confidentiality, and that has been breached.
So is it your opinion that if the question were put to the Commission today as to how these documents became public, the Commission would deny making them public?
I have no idea what the Commission would deny or not deny. We've sent them today a letter. I understand he doesn't do email, so we've sent a letter to the Commission today asking for an investigation by the Australian Federal Police. I don't know what they'll say about it, but I do know there needs to be a proper independent investigation of this matter because someone leaked documents which were not supposed to be in the public domain.
The submissions of council assisting were made public last year as well. Why didn't you take similar legal action then?
Well, the submissions of council assisting were made public last year in accordance with the practice direction. They were put on the court book. Lawyers had an opportunity to prepare responses to them. They were not leaked as a preemptive strike by individuals determined apparently to politicise this commission or to continue to politicise this commission. There was nothing done last year that was in breach of the practice directions. What has happened today clearly is.
Council assisting have also called for a recommendation of criminal charges against Darren Greenfield, Cfmeu official in New South Wales. How do you react to that?
Well, Mr Greenfield has strongly denied the allegations that have been made. No finding has yet been made in relation to Mr Greenfield. We believe that the submissions are a stretch, but Mr Greenfield enjoys the confidence of the union. Mr Greenfield will have his right to defend himself in the Royal Commission, and his lawyers will do so. Like anybody else, he is entitled to the presumption of innocence, and he should not be held up to public attack by a submission being made in what is frankly a kangaroo court.
Do you have any concerns whatsoever about his dealings with Mr George Alex?
I am concerned that there are companies like Mr Alex's company in the building and construction industry. I'm very concerned about it. There are lots of companies in the building industry, unfortunately, where there are employers who are associated with shady dealings and the underworld. It's not the majority. Most employers in our industry are good, hard-working people, and we generally enjoy good relationships with them. But clearly there was a pattern of Phoenix activity with the Alex group of companies. The union recovered, from what I've seen so far, the Royal Commission appears to have neglected to notice this. The union recovered $1.5 million of workers' entitlements from the Alex group of companies. Now, nobody else did that. The Fair Work Ombudsman didn't do it. The Fair Work Building Commission didn't do it. The Trade Union Royal Commission sure as hell didn't do it. The union, the Cfmeu, were the only people, and Mr Greenfield, the evidence is, were the only people that went out and recovered entitlements for those workers. So he asserts his innocence. We have confidence in him and he will defend that position. But I would say we've got a lot of concerns about a lot of employers in this industry. This Royal Commission doesn't look at them. They only look at unions and workers, and that should tell you something about the political agenda that's at work here.
If the Cfmeu is able to openly confront large corporations like Grocom and Boral, why hasn't the Cfmeu been able to confront companies like Mr Alex's and simply shut them down as opposed to dealing with them on an ongoing basis? Well, sorry, I should say companies that have been linked to Mr Alex's.
Well, the union doesn't shut companies down. The corporate regulator registers these companies. But the evidence is that the union went in and recovered $1.5 million worth of workers' entitlements from the Alex group of companies. That's not me saying that. That is the documents. That is the documentary evidence which has been provided to the Commission. Now, I think that we need to review and be very careful about our dealings with these companies. But it's not our agenda to go and shut companies down. We do deal with very large corporations, and that's why workers in the building and construction industry need a strong and effective union. They need it as a counterbalance to the power of the big construction companies, the big developers, and of course the Liberal Party who back them up every bit of the way.
Do you have any concerns whatsoever about the nature of the relationship between Mr Greenfield and Mr Alex?
I think that we need to be much more careful in how we deal with these sorts of characters, and the union is implementing internal governance structures to ensure that where we have companies which are controlled by, let's say, colourful racing identities, that we have transparency in our dealings with them. We don't want to be in a situation where our organisers are dealing with them one out. That is for reasons, obviously, of transparency and probity, but we also have a situation where we've got an obligation to the occupational health and safety of our officials, and I would not like to see some of our people, just on a safety basis, dealing with some of these individuals without witnesses.
Dave, are you confident that all ACET and super entitlements were eventually paid to workers as owed by
Well, it's a very difficult thing to be 100% confident about that in all cases. We're in an industry which has shifting and you know, opening and closing types of employers. It's an industry with transitory labour. It's a daily hire industry where workers come and go, and I can't give a certificate for any employer in this industry, and won't do so, saying that they have paid every cent to every worker. But where claims have been submitted, the union has pursued them, and we have on the documents recovered over $1.5 million for workers employed by the Alex group of companies, if you want to call them that. I don't know any other organisation that's recovered 1 red cent for those workers.
Today's release of documents also notes that there's no insufficient evidence to make any findings against Mr. Parker in terms of questionable dealings. What's your comment on that?
Well, my comment is that obviously that's the way that council assisting saw the evidence.
Were the payments from the Jane group of companies appropriate, do you think, and transparent? And is that something that that you support as a model of unionism?
I'm sorry, from which group of companies?
This is the Mr. Jane's companies. These are the Chinese dealings. You know, Brian Parker went on holidays, and separate case study to George Alex, so I've moved on.
So you said Brian Parker went on holidays. What are you getting at?
To China, and there was evidence about him.
Are you making an allegation about that?
No, just in terms of.
Oh, I'm sorry, it's just that you raised it in front of a
Yeah.
press conference. I assumed you were making an allegation.
I know it's unclear who paid for those flights. He said that he paid for them in cash, but it can't be proven. And so what I'm asking you about is donations to the Cfmeu from these companies. Do you think that's an appropriate model of unionism?
Well, I think what you've done there, and this has been an unfortunate feature of some journalists' reporting of these matters, is you've conflated 2 entirely different things. Mr. Parker was asked to account for holidays he took, and he gave answers on that, and no evidence has been put that he said anything wrong. So it's interesting you asked that question. In relation to donations from construction companies, donations that go to the particular charities may be appropriate, but we certainly need more governance, more openness about it. I don't think that the way that those donations was done was ideal, but there's no allegation and there's no evidence that 1 cent of those went into a union official's pocket.
You say they're not ideal. Could you elaborate on that?
Well, I think that they need to be open. I think they need to be discussed with the members, and I think that whilst we are very critical of the Royal Commission, it is a political process. It's been called for base political motives. That doesn't mean we won't take learnings from it, and the union is engaged in a thorough and root to branch review of all of our governance procedures, and that will include how charities are dealt with, how raising money for things like the building industry picnic, which is attended by tens of thousands of workers, are raised. There are certainly appropriate times for the raising of monies by charity, but it ought to be open, it ought to go through the governing bodies of the union, and it ought to be openly dealt with in front of the members. So we'll take some learnings from that.
Speaking of politics, do you have any view on the Labor's deal with the government over the China Free Trade Agreement? I know we've heard from the ACTU, we've heard from the ETU, just wondering how the Cfmeu feels about it.
Well, how we feel about it is this. We think that free trade agreements are basically there for big corporations. We don't think they're there for working people. That being said, the unions run a really strong campaign, as have other trade unions, about this. And it's amazing, when you see the Liberal Party accusing people of racism, people that choose to associate themselves with far-right groups and appear in public with them. Our union's very proud of the fact that we represent workers from every country in the world, including a lot of workers from China. We're proud of that, but we're also proud of the fact that we're going to defend living standards in this country, and that's what this campaign has been about. Labor has made some important gains in terms of underlining protections for workers. They've made some important gains in terms of ensuring that there is labour market testing, at least on the books, but they've got a lot more to do, and they'll have a lot more to do if Labor is elected in making sure we have proper protection of workers who are here as guest workers on visas, but in particular that free trade agreements are not used to subvert and undermine hard-won standards that Australian workers have been fighting for generations, and that are community standards here. Visas should be used, 457 should be used where there are genuine skill shortages. Working holiday visas should be for people having a holiday, not being brought here as factory fodder, and student visas should be used for people to get education here and do a little bit of work to support themselves while they're here. They shouldn't be used in the way they are commonly being used, which is to replace entire local workforces. And what we've seen recently with the 7-Eleven case, what we've seen in the building and construction industry in a lot of areas shows you that there is massive rorting of visas, and both parties need to get in line with supporting the interests of ordinary Australians, not the interests of big business and labour hire companies that want to rort the system.
You say both parties. Do you think Bill Shorten's failed workers by letting the deal go through with only, these minimal sort of safeguards added?
No, I don't think he has. I think what you've seen, as I said in my previous answer, is very important protections which have been put in relation to labour market testing and in relation to particularly ensuring that there are decent minimum wages paid. But it's one thing to have these things in law, in the Migration Act. It's another thing to have them actually implemented. And we call on the Labor Party to lay out a vision about how they are actually going to ensure that workers that are here on temporary visas are protected, because they're certainly not at the moment. I remember when Brendan O'Connor, when he was the Minister for Immigration, said there were 10,000 visas being rorted. The Liberal Party howled him down. All the big chiefs at the Australian newspaper and Financial Review said that he was making it up. Can anybody deny now that there are tens of thousands of workers on temporary visas being ripped off? That's proved to be factual, and some of those people ought to eat their words.
Aren't you just making a lot of trouble for the opposition leader by continuing the campaign? If you say he's made important gains, and why be a thorn in his side and continue to campaign against something that Labor and the government now have bipartisanship on?
Well, I'm not sure where you get that question from. We don't mind. We will be a thorn in the side of any politician that doesn't stick up for working people. That being said, the concessions that have been gained by the Australian Labor Party under the Free Trade Agreement are significant. They're very important, and they would not have occurred if there had not been a trade union campaign, and they would not have occurred if Bill Shorten hadn't stood up and took on the vested interests that tried to howl him down over this issue. So we think that we'll take the progress that's been made, but we'll be very keen to make sure that the Labor Party, and indeed the Liberal Party, begin thinking about the interests of ordinary Australian workers when they frame migration and workplace policies. And I think we're just about done on that one, unless there's anything else on the Royal Commission.
Just one final question on the Commission, Dave. You said that the release of those documents shouldn't have happened today. When, in your view, is the appropriate time for them to be made public?
Well, it's not for me to say. You see, the Royal Commission, under the legislation that governs them, which is legislation that carries prison sentences, very serious consequences, has made a decision about the process of releasing them, and that has been breached. So, it's quite simple. We should not see the covert release of material which is designed to damage people who are subject to very serious inquiries under a Royal Commission. If the Royal Commission believed that releasing it in this way was appropriate, they should have said so in their practice note.
So you're saying they should never be made public?
No, that's not what I said.
Then at what point is it appropriate for them to be made public?
Well, I'll go back again. The Royal Commission established a practice note. You can look it up on the website. It says the circumstances under which these matters should be made public. And what has previously happened is that matters are put on the court book and they are either then tendered to evidence and then become public, or an order is made that they be released on the website by the Commission. They're not on the website. They've been given out in a planned drop to the media. The public can't see them, only selected journalists could. And we think that's crook. Thank you.